Meeting to order. Welcome to meeting number 58 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to House Order of March 27, 2023, the committee is beginning its study on Bill C-41, an act to amend the Criminal Code and to make consequential amendments to other acts. Today's meeting is taking place in hybrid format pursuant to the House Order of June 23, 2022. I think actually today everyone's attending in person, so I won't go through the hybrid format. Today, just for the minister and anyone that's new, I think I have a lot of new members today. I use cue cards, so when you're down to 30 seconds, I will raise the yellow cue card, and when you're out of time, the red, and I ask you to just wrap up in that so I don't have to interrupt you. We are pleased to welcome the Minister of Public Safety and Emergency Preparedness, the Honorable Marco Mendocino. Welcome, Minister. And also, I think today we have from Public Safety, Sebastian Albertin Guerrero, Assistant Deputy Minister, National Cybersecurity. Apologize for my pronunciation. Department of Justice, we have Robert Brookfield, Director General and Senior General Counsel, the Criminal Policy Section, and Glenn Gilmore, Counsel Criminal Law Section. From Immigration, Refugees and Citizenship Canada, we have Selena Beatty, Director General, Policy and Outreach, Afghanistan Sector. And I think we may have some others as well, but we welcome you and are glad to have you there. The Minister, you'll have the floor for 10 minutes as usual, and your opening remarks will be followed by questions from the members of the committee. The floor is yours.
Thank you very much, Mr. Chair, and to colleagues. And just by way of some housekeeping, I am very pleased to be joined by a number of colleagues, as you pointed out, Mr. Chair, from my department, Public Safety, from Global Affairs, and from Immigration, Refugee, Citizenship in Canada, and of course our colleagues from Justice. And I am seated next to Monsieur Aubertin Giguère, who is one of our officials from Public Safety. I think you also said that I was the Minister of Public Safety and Emergency Preparedness. I know our colleague, Minister Bill Blair, might take, I say with a bit of a smile, some umbrage at that. He's doing a very able job at emergency preparedness in his capacity as Minister of that portfolio. But on to the subject matter before us, I am very pleased to be able to discuss Bill C-41 with all of you, which is an act to amend the Criminal Code and to make consequential amendments to other acts. Colleagues, as you will know, Bill C-41 creates an authorization regime to facilitate the delivery of international assistance in geographic areas controlled by a terrorist group as defined in the Criminal Code. As you will know, and given the state of affairs in Afghanistan and other troubled regions of the world in which there are conflicts, this bill is crucial. Allow me to explain. As I implored all members when our government tabled this legislation, there is a humanitarian crisis in Afghanistan. After 4 decades of conflict, political and economic instability, and a global pandemic, the Taliban's takeover in August 2021 has exacerbated an already dire situation. Under the Taliban regime, we have seen violence, the erosion of fundamental human rights, and the brutal assault, torture, and killing of women and girls and religious and ethnic minorities. Ils ont besoin d'aide en ce qui concerne des...
They need assistance with regard to basic elements like food, health care, housing, protection, and education.
To do everything in our power to assist the people of Afghanistan. And I would note that our ambitious commitment to welcome at least 40,000 Afghan refugees has hit a significant milestone very recently. We just welcomed the 30,000th Afghan refugee on Canadian soil. And that is something that I think ought to be celebrated, as those individuals will now have the chance at a better life. À l'heure actuelle, le code...
Currently, the Criminal Code contains provisions, strict provisions to combat financing of terrorism. More particularly, pursuant to 8930B, it is forbidden to provide property, knowing that they could be used by a terrorist group or that this group could benefit from that assistance.
Provisions have a significant impact on Canada's ability to deliver aid and other forms of international assistance, including in Afghanistan. And that's because although the Taliban is the de facto authority of Afghanistan, it remains a listed terrorist entity under Canada's criminal code. As such, aid delivery has the potential to benefit them and thereby contravening the criminal code in doing so. Canadian organizations, including nonprofit aid groups and departments of the Government of Canada, risk inadvertently breaking the law if they attempt to provide aid within Afghanistan. Bill C-41 will provide clarity and assurance for Canadian organizations that they are not committing a terrorism offense when acting within the scope of the authorization that is contemplated within the bill. Je tiens à souligner que le régime d'autorisation
I stress that the authorization regime would not be limited to Afghanistan, but would be applicable to any geographic area controlled by a terrorist group in order to respond to similar situations.
Our government considered all possible remedies, including the possibility of a humanitarian exemption to the existing law. However, a statutory carve-out would not provide, in our submission, the same security checks and balances and would risk greater abuse of the provision. The approach outlined in Bill C-41 best mitigates those risks by potential terrorist actors. Banks and financial institutions have also called for these security measures. Allow me to outline the bill's extensive guardrails. This begins with collaboration across various portfolios, some of whom are represented at the table with me today. The Minister of Foreign Affairs and or the Minister of Immigration, Refugees and Citizenship would first refer applications to me in my capacity as the Minister for Public Safety. Le ministre ayant fait la demande devra également être.
The minister submitting the request must be convinced that the candidate will be able to disperse these funds in a conflict situation and take into account the effective administration of these funds. Once the demand is received, the request is received, the security services will undertake a security review to evaluate the impact of this funding or this authorization on the financing of terrorism.
Would consider whether the applicants have links to terrorist groups or activities. The authorization could be granted once I am satisfied in my capacity as the Minister for Public Safety that there is no practical way of undertaking the proposed activity without a risk of terrorist financing and that the benefits outweigh the associated risks. The assessment will take into account the referral received from the Minister of Foreign Affairs or the Minister of Immigration, the security review findings, the measures to mitigate risks, and any other factors considered appropriate. If an application is refused, those applicants would be able to seek recourse through judicial review. Les autorisations seraient accordées pour
Authorizations would be granted for a period of up to 5 years and would apply to any person or organization involved in carrying out the authorized activity.
Authorizations may be revoked if the applicants fail to comply with the conditions and the terms that are set out within it. The Canadian Security Intelligence Service, the RCMP, the Communications Security Establishment, and the Canada Revenue Agency will also be involved in security reviews. To ensure that the authorization regime is held accountable, as Minister of Public Safety, I would provide an annual report on the regime and conduct a comprehensive review within 5 years of the bill's coming into force. The bill sets forward clear operational guidance, and the application process is free. Let me be clear. Terrorist financing remains a criminal offense and a serious threat to our interests both domestically and abroad. An authorization would not shield efforts to benefit a terrorist group. Such activities would remain criminal. It is vital that Canada continue to provide international assistance in Afghanistan as well as in other regions where there is protracted conflict. To facilitate this and prepare for future situations posing similar constraints, the proposed amendments to the Criminal Code are critical. It is transparent, it is charter compliant, and the provisions that are set out in this bill are in accordance with the law. Le projet de loi C-41
Bill C-41 responds to the immediate needs in Afghanistan while also being adaptable to future needs.
history. Canada continues to help our global community. I want to thank you, Mr. Chair, for the opportunity to provide some prefacing remarks, and I also want to take a moment to thank all of the members of this committee for their advocacy and for their leadership in bringing this important issue to the fore. And we now have an opportunity to remedy some of the constraints which have previously prevented Canada from doing more to help the people of Afghanistan and other vulnerable individuals who have come under the thumb of autocratic and oppressive regimes. And I look forward now to your questions and comments. Merci.
Thank you.
Minister, appreciate your timeliness on this. I'll begin the first round, which will be 6-minute rounds, beginning with Mr. Genuis for 6 minutes.
Thank you, Chair. Thank you, Minister. I think it's important to underline where the debate on this bill is in this Parliament. Nobody in any of the opposition parties, I think, disputes the urgency of the humanitarian crisis or the need for legislative action. In fact, the issue has been the significant delays from the government side moving this forward and concerns about whether the regime will work effectively for those organizations who need to use it. At the time Kabul was falling, your government, instead of attending to the situation, was calling an election. We had an Afghanistan committee that called for these changes a year ago. We haven't seen anything on it until now. We had a motion at the Foreign Affairs Committee that I moved in the fall, a second motion at the Foreign Affairs Committee earlier in the spring. So you're going to have strong agreement that action is required, and I think in principle with the legislation moving forward, we wish the government, I wish the government had acted earlier, and I remain concerned about just the effectiveness and the efficiency of the regime helping organizations get the aid to where it needs to go. I want to ask specifically, how long do you expect it to take to approve these kinds of applications? Can we expect that all of the enabling regulations and processes will be in place to allow humanitarian organizations to rapidly deliver the aid that's needed once this legislation passes? In particular, that we don't come near another winter in Afghanistan without the legislation not only being passed, but exceptions granted so that it can be used.
Well, first, Mr. Chair, through you to Mr. Genuis, I share the concern and the sense of urgency in aiding the people of Afghanistan who, as I pointed out in my introductory remarks, have been subject to human rights violations, oppression, torture, killings, and disproportionately towards women and girls and religious minorities. And that is precisely why, as part of the bill, we contemplate having a streamlined process, one that will efficiently work with organizations that have put themselves forward as candidates for authorizations to deliver this aid, but with the requisite security checks that are required both to protect the integrity of the program as well as to guard against any potential risks that may flow from the funds to, or where, I beg your pardon, a de facto a regime like the Taliban Authority, who is listed under the Criminal Code as a terrorist entity, may inadvertently benefit. We need to strike that balance and do it in a way that promotes transparency, accountability, but with the sense of urgency that I think all parliamentarians are united behind in getting that aid to Afghanistan.
Thank you, Minister. I won't repeat the question around what you expect to be the specific timeline. I'm quite tight for my own timeline for questions. But if you can follow up in writing, or your officials can follow up with an estimate of the turnaround time that organizations could expect in terms of applications. I know we need to strike a balance, but we would like you to try to quantify what exactly that balance would be. Another specific question: would this legislation only apply in the case of areas controlled by listed terrorist organizations? What I'm hearing hearing from some of the stakeholders is that it doesn't appear to only apply to territory controlled by listed terrorist organizations.
Well, certainly that is our top priority. And those organizations which have been listed as terrorist entities under the Criminal Code meet that definition and, by extension, pose a risk and a threat to Canadian interests both here and abroad, as well as to the people where they may be operating, and certainly within the geographic areas where we are trying to get aid to. I would submit, Mr. Genis, that through that lens, that it is important that as we receive applications and as we screen both the principal sponsors of those applications as well as the activities that will be authorized under the regime, that we look at all of the circumstances.
Okay, but can I just zero in on the specific question, which is the intention of this legislation to only deal with situations where territory is controlled by a listed terrorist organization, or is it intended to apply to cases of organizations that are concerning from a certain perspective for whatever reason, but are not listed as terrorist organizations?
As I was saying towards the end of my answer, the primary focus is to make the assessment.
But not who the primary focus is. Is the intention of the legislation to only apply to listed organizations or to apply to organizations that are not listed?
Mr. Genis, if you'll allow me to finish my answer, I think it will be responsive to the point that you're making.
Okay, quickly, please. I want to get one more in before.
We are making this assessment through primarily the listing of terrorist organizations as defined under the code, but the security review will look at all of the factors on the ground and assess and be sure that we are able to mitigate against those risks. So I think you will agree that yes, while, for example, in Afghanistan, we will be making these assessments on the basis of the reality that the Taliban are the controlling authority in that region.
Sorry. I want to get one more question. Respectfully, I don't think that's a very clear answer, but I would welcome a follow-up in subsequent rounds or in writing. I wanted to ask, this bill contemplates other organizations being listed and the implications there. Could you give us an update on the government's considerations around listing the Wagner Group as a terrorist organization?
Well, first, I would say we're vigilant about making sure that we list entities that do meet the definition, and we rely on our nonpartisan professional public servants to provide us with the best possible advice on that exercise. And where appropriate, we move expeditiously to ensure that we are listing those organizations so that Canada is not a safe haven either for the flow of terrorist funds or is a safe haven for any terrorist activity.
Thank you. Thank you, Mr. Genis. The next round of 6 minutes goes to Ms. Briard for 6 minutes.
Merci, Monsieur le Président.
Thank you very much, Chair. Hello, Mr. Minister. Thank you for being here. It's terrible what's happening with the situation of women and others, as you mentioned, in Afghanistan and in the area of health, security, education, and I think we talk about that situation enough, and it's important to help Canada provide assistance. And with regard to this new regime, have you consulted with NGOs and to ensure that these will respond to their needs and to help them act and to ensure that it will not be an onerous task for these organizations to undertake the requirements? Thank you very much. I would ask, I thank my colleague for this question. The process for this new regime is a very efficient one. One of the reasons why we have to prioritize the review and take into account as well the situation in the field in Afghanistan. This is a very serious situation for women, for girls, for other religious minorities as well. And that's why we have to cooperate and work with civil society organizations that want to provide assistance in the field. And we have to stress that we understand that we have to be very careful. And we have consulted and will continue to consult these organizations, and we will look for solutions where there are challenges with regard to providing these essential services. And the last thing that I'd like to mention is that with regard to the flexibility of this regime, this new regime, to ensure that we can provide services for and assistance for food, health, education, women programs to protect human rights, and services that can ensure accessibility to our immigration program. So the program, the regime will be flexible, and this is what we have discussed with the organizations concerned. And you chose to adopt this new regime with regards to an exemption, and why did you not take a more comprehensive approach? This is a very good question, and I know that there are members of the committee and other parliamentarians who suggested a total exemption, but in the government's opinion, we have put forward a bill that is meant to have a program that provides a review procedure to ensure that these services can be offered to the people we want to assist, but with the proper checks. The government believes that this bill represents a balance between these various priorities. Is this something that exists, that kind of thing that exists in other countries? Are there any examples in other countries of this type of thing? There are other mechanisms and possibilities, but the basic point is that the government acts on the basis of our consultations with the concerned organizations, with human rights defenders, and we believe that this bill has found a very good balance. It will be effective, and this the principles of transparency, integrity, and protection of human rights. What are the national security challenges that that led you to conceive this new authorization regime? I think this is a very significant challenge. The situation in Afghanistan is a very complex one. There is a terrorist organization that is banned under that is considered one by the criminal code. The crisis is very grave for the population of Afghanistan. So there would be many possibilities if we did not have a system like what we're providing or proposing to provide assistance to a terrorist regime. That's why we decided to propose a mechanism that will protect the integrity of our programs, but while remaining flexible to ensure assistance can be provided to the people in the field.
Go to Monsieur Brunel Duceppe, and welcome to the committee today.
Merci.
Thank you very much, Chair. Thank you to the witnesses and to the Minister for being present. And I think in 2 December 2001, there was a resolution 2515 that was voted with regard to the efforts in Afghanistan. I was one of the first to raise the challenge in 2022. I put forth a motion to find a way to assist in the field, and I think your government blocked my efforts, and Mr. Sajid and others said there are problems that have to be solved. And why did it take you so long, though? First of all, thank you, Mr. Brunel Duceppe, for your leadership in this area. I know you've devoted a lot of energy to it to move this forward. And yes, I share your concerns to respond urgently. There is a situation in Afghanistan which is so complex. The conflict, the evacuation to the United States. There are so many factors that have had an influence. So it's the complexity of the file. Yes, absolutely. So you've had conversations to find solutions, and you say that it's the complexity of this file that's taken you so long. But that existed right at the beginning. There's nothing that's changed since we raised this problem in the first place, and so it's taken you a year to draft Bill C-41, and I think when the Liberal government in 2022 adopted 1127 resolution, UN resolution, and how have you implemented that? You mean that it's taken so long, 15 months more or less, to put forward this C-41? There is no single factor that has affected our response to the situation in Afghanistan, except for the epidemic, which, of course, had an effect everywhere. But, Minister, in a few weeks, we managed to enact many programs to deal quickly with the epidemic, in the middle of an epidemic. And we very quickly adopted special measures to respond quickly. Do you think that it's more important to deal with the problems of Canadian workers than for a child in Afghanistan that needs medical care? I think that the military left some years before, and we had a significant operation to bring back or bring in refugees. But yes, I just want to give you some context to explain the time delay. In your consultations with these organizations, as you know, there are organizations that, like the Red Cross or others, that are very credible. Yes, we have good relationships with many of these organizations, and there are other arrangements with well-known organization. I hope that this process will move forward efficiently, but I think that this will have to go through the process that I've described. But I think that we're talking about a bill concerning a reasonable time for being authorized. A reasonable time for an aid organization, it can be a very, very long time. And is there any way that we can know how long these authorizations will take? What is a reasonable time for getting an authorization for providing assistance in Afghanistan, for example? Well, we're going to continue to study the situation as we move forward with this bill and also with the ensuing regulations and with consultation with the organizations and to move forward. But how long? How long would be a reasonable time to get an authorization? It must be effective, and it must be not something that would pose any risks. Well, this is something that we'll have to decide in our consultations. But you talked about organizations. Did you work with Médecins Sans Frontières, for example, or other organizations in developing your new proposal? We had extensive consultations with organizations, and there were many opportunities, many opinions discussed. But in the opinion of the government, our proposal is the best. Did you consult Médecins Sans Frontières? Thank you, Minister.
I will next go to Ms. McPherson. Welcome.
Thank you very much, Mr. Chair. It's nice to be in your committee today. Thank you for being here, Minister. Thank you, all of you, for being here and providing your testimony. I have to say, I worked for about 20 years in the nonprofit, the international development and humanitarian sector before I became a politician. And so after 18 months of waiting for this legislation, I was expecting something good. And unfortunately, that's not what I see with C-41. So forgive me, but I will speak with my international development hat somewhat today. You spoke about the balance needed between preventing funding going to terrorists versus helping humanitarian. With all due respect, Minister, you got the balance wrong. You got the balance wrong on this one. And the reason I say this is for a number of different reasons. First of all, we're creating barriers to humanitarian aid. I wrote to you immediately when this legislation came forward, and I didn't get much of a response, but I outlined exactly why this legislation doesn't do what you think this legislation should do. So I have lots of concerns about how it will be implemented, how we are going to take an overstretched and under-resourced Global Affairs Canada to do this work. But ultimately what this does is it interferes with international humanitarian law. And you talked about the balance. You talked about how this was the best thing you thought could happen. Why do you think the Canadian government felt that this was the best thing to happen when we look at governments like Australia, the EU, New Zealand, Switzerland, the UK, the United States, and they all listened to the experts in their field. They listened to the experts that do this work, that asked for a humanitarian carve-out. Why did Canada choose to not go with the humanitarian carve-out when very clearly other countries did? Other countries that I think we all know exactly what they're doing on the ground, that have respect for humanitarian assistance, have respect for anti-terrorism legislation. But yet Canada is the only one that put barriers up for humanitarian organizations instead of making it easier for them to be on the ground, doing the work, helping Afghans.
Well, first, Mr. Chair, and through you to Ms. McPherson, I just want to thank you for your leadership in this space. I know you've been an advocate for many years, and I respect very much the opinions that you bring to this debate. I would say to you that in this bill, we have put forward a Canadian-tailored approach that does achieve the twin pillar objectives of both promoting flexible pathways to offer assistance, and I have enumerated them. And I do think, and I say this respectfully, that a number of organizations that work in the same space that you have advocated in are broadly supportive of this regime.
You've put them in a situation, Minister, where they have no option but to be supportive. They waited 18 months for legislation. They're willing to take the crumbs that you've put on the table because you did not come with the right legislation. So they're willing to take the crumbs that you've put forward because that's all you've brought forward. This is bad legislation. Will you be open to amending this legislation to make it stronger?
Well, first, I would not characterize the approximate $4 billion that we have put into Afghanistan since 2001 as crumbs, and I think that does a disservice not only to the
Minister,
organization
you
that serves
know
in
very
space.
well that's not what I'm speaking about.
What I'm getting at is that we are talking about a program that has been set up with the input and the consultation of organizations that work in the same space that you do. And I take a more, I think, I take a more optimistic view of the consultation and the input that they have provided us. I am not as skeptical as you are that they view this program as being crumbs. I say that respectfully, but I also want to point out some other things. It is precisely because you and many others want to see that help get to the ground that we have to be sure that Canadian funds are not misappropriated. So what you are characterizing right now is as barriers, and I want to hear you out on how we can work through those in this process. I see as potential risks to our national security. I see as risks to the security of the Afghan people. So these are not barriers.
Why do you think the U.S., the EU, the U.K., Australia, Switzerland, why did they not see that balance the same way you did? Why do you think that Canada is the only country that saw it that way?
I say this with respect, but I am not here to defend the position of the United States or any other country. I'm here to articulate the rationale for Bill C-41, and I think that the government has put forward a reasonable and compelling case.
A fundamental principle of humanitarian assistance is neutrality and impartiality. It's a fundamental part of human rights law. Of course, you would know that. By getting approval from the Canadian government through the process that you've put forward, do you not worry that that will actually impact organizations' ability to claim impartiality and neutrality? Do you not worry that you're actually going to be putting organizations in danger because you're making them go through this process?
I think you're right to articulate the concern, but I also think, looking at the language of this bill, that we are promoting an approach and a regime that gets that balance right. And the reason why I say that is, first, we take advice from the public service. The public service are not partisan, they're not political. I would also just add one last point. Certainly, I will endeavor to exercise the discretion that is afforded to this office in this bill in the best possible way. But in the event that there were any concerns about the way in which that discretion was exercised by me or any successor, there are judicial review mechanisms specifically contemplated by this bill, which affords transparency and accountability. It
starts as a politicized process, and anyone can take that politicized process and take it to the next step. The next government may not be as benevolent as you are for humanitarian organizations.
Well, I appreciate the benefit of the doubt.
Person. I'll next go to a round for 5 minutes, beginning with Mr. Brock for 5 minutes.
Thank you, Chair, and thank you for your attendance, Minister, and other department officials. I want to continue the discussion that, or the Q&A that Ms. McPherson finished off with. One of the questions I was going to ask is how this particular piece of legislation was framed in terms of how other democratic nations across this world have dealt with this humanitarian crisis. And I get the impression, listening to the framing of her question and, Minister, your responses, that Bill C-41 appears to be an outlier with respect to the other nations that are currently providing exceptions, humanitarian exceptions, in getting humanitarian aid to Afghanistan a hell of a lot quicker than Canada is. Is that a fair assessment?
I certainly believe that this bill presents a Canadian tailored approach, but we also take a very tailored approach when it comes to defending human rights through our refugee program. And so it's true we may be exceptional in that regard, but I think it puts Canada in a very strong light when it comes to protecting vulnerable individuals who have been oppressed or tortured or killed as a result of the fact that they are women or young girls or religious minorities. And I think this bill does allow us to try to save as many lives as possible.
Okay. You mentioned that this particular bill is charter compliant. Is there a charter statement?
Minister Lametti would be responsible for that analysis, and I'm happy to defer to our justice officials who are here on that if you'd like to hear from them.
I'm concerned about the privacy aspect in terms of releasing confidential private records from the CRA as part of the risk assessment and intelligence gathering. How does that impact Section 1 of the Charter?
I'm happy to say a few words about it, and then Mr. Brock, if you'd like to hear more expand. But first, I want to assure you, and I thank you for raising the question of privacy. This law will comply with Canada's privacy laws, which is to say around retention and storage, and I would say most importantly for the purposes of the administration of this bill, the funds and the sharing of information that will be authorized that will enable those funds to get through will be done for that purpose and that purpose only. And as to your question around Section 1, as you know, the interplay between Section 8 of the Charter and Section 1 is somewhat unique. There are some who would say that in a lot of ways, Section 1 is built into the reasonableness analysis under Section 8, but I assure you that that impact analysis is being done by Justice, and I will turn to my colleagues to say more if they wish to add.
Thank you for that, Minister. I'm going to cede my time to my colleague, Mr. Genius. Thank you.
Thank you, Chair. Thank you, Mr. Brock. I do want to press you on this issue of what constitutes a terrorist organization for the purpose of this legislation, because I think this is really important. The Criminal Code defines a terrorist group as either a listed entity or an entity that has as one of its purposes or activities facilitating or carrying out any terrorist activity. So a terrorist group doesn't necessarily mean a listed terrorist group. There could be terrorist groups that are not listed according to the Criminal Code. Now, the definition of terrorist activity is long and detailed.
I'm somewhat familiar with it.
But it could, from my reading, include not just non-state actors, but also state actors that engage in violations of international law. There's no clear exclusion that other states, in certain cases which Canada recognized, couldn't necessarily be considered terrorist organizations. The legislation puts the onus on humanitarian organizations to determine whether or not they need to apply for this exemption. So in a case with a listed terrorist organization controlling territory like Afghanistan, it's relatively clear-cut that an exemption would be required. There may be cases where it's not clear whether or not an organization is engaging in terrorist activity according to the Criminal Code or not, and therefore whether an exemption is required. And this legislation could actually create additional problems for organizations wondering, do I need to apply for an exemption or not, operating in this particular area where an organization controls territory that may not be listed. So to me, that's a clear problem, and it speaks to the need for clarity around whether we're just talking about listed organizations or whether we're talking about any organization that's defined as terrorist. So what is your response to that, and would you be supportive of providing that clarity in this legislation going forward?
The short answer is yes. I realize we're tight on time, but I think you raise a valid point. I'd say two things in response very quickly. One, I actually think the flexibility of the terrorist definition is a positive thing in a case where we're trying to get aid to an area where the de facto authority may not be a terrorist entity, but there may be terrorist activity. But secondly, I would just add to that what you may have characterized as a problem, I see as an opportunity to work with those stakeholders in this space to make sure that we can help them navigate that process.
Minister, that answer concerns me more because the organizations don't benefit from this flexibility. They're left holding the bag, not knowing whether or not they're going to be prosecuted if they proceed in a particular case. They need clarity in law.
Time is up.
We'll provide them that.
I'm going to go to the next member, and that's Mr. Nakvi for 5 minutes.
Thank you very much, Chair and Minister. Welcome, and officials. Thank you for being here. I want to take a step back a bit because I think in this very important, intense conversation, it's important to be reminded of some really crucial facts. In my view, one of them is the fact that Afghanistan is a very troubled part of the world. It's a very dangerous part of the world. And I'm sure you'll agree that the regime, the Taliban regime that has taken over Afghanistan is an absolutely brutal organization that is against women, that is against LGBT community, have very little tolerance of all kinds of minorities, and have acted in the past in terrorism-related activities. And they're the one who are in charge in that country, and they are violating the rights of their own citizens under the government they have put in place at this moment. I'm sure you're going to agree with my analysis or assessment, Minister, of what's happening in Afghanistan at the moment.
Without question, Mr. Naqvi, and just to add a few statistics which are truly horrifying, and I think underline the urgency which has been a consistent theme throughout the interventions today. We are presently looking at 20 million Afghan people who are suffering from acute hunger. In 2023, a total of 28.3 million people, or 2/3 of the population, are in need of humanitarian assistance. And that constitutes the need to get aid to 33 out of 34 of the provinces in Afghanistan. So your question and your comment is very much borne out by the statistics. And behind each and every one of these aggregate statistics, there is a human life. And we are trying to save as many of those lives as possible.
So this is a draconian government that is violating people's rights and not only is undermining democracy right now in Afghanistan, which the Afghani people themselves and Western countries worked extremely hard to establish, but their actions are also causing significant harm to their own people, as you stated by the data that you just shared. In addition, Minister, can you share with us, is Canada in a fairly unique position to declare Taliban as a terrorist entity or terrorist organization when we look at other peer countries?
I wouldn't say we're in a unique position. I know that other countries have their own regimes, and I'll confine my comments to the decisions that we take as a government, which is we believe that the Taliban meet the definition of a terrorist entity under the Criminal Code, and that in creating this legislation, we are mindful that as the controlling authority, there are risks that need to be mitigated if we choose to amplify our humanitarian efforts on the ground. I just want to.
You're going exactly where I want you to go, and because I want to very clearly ask you, what is the balance in light of everything that we've just spoken about in terms of what's happening in Afghanistan and the impact of Taliban's regime on the people of Afghanistan? As Canadians, as we try to provide help and aid to Afghan people through various NGOs, what's the balance you're trying to maintain here? What's the balance you're trying to create through this legislation?
I think it's a very fair question, and it's important because it informs the twin objectives of this legislation. The two priorities that we are attempting to balance here are, one, to create a vehicle that will allow us to deliver more humanitarian aid flexibly, and on the basis of the input that we have received from many advocates and organizations that operate in the humanitarian space. That includes life necessities like food and shelter and education and support for those who may wish to come to Canada through settlement services and immigration services. And secondly, making sure that as we create those pathways to deliver that humanitarian aid, that we reduce as much as possible the potential that those Canadian funds will be misappropriated and used to support the terrorist activities of the Taliban. Those are the two priorities that we are trying to get the balance right on, and we believe that this project does that.
Thank you, Mr. Naqvi.
Thank you.
Next, we'll go to two 2.5-minute rounds. We begin by Mr. Brunel Duceppe for 2.5 minutes.
Do you want this?
Merci, Monsieur le Président.
Thank you very much, Chair. To receive an authorization, NGOs must make a request to Global Affairs. Is that correct? It's Foreign Affairs or our colleagues at Immigration. So there's no single window, single wicket, and so they can go to either ministry. And is there any way of starting the process outside the ministry? I'm going to ask my colleague to reply because I think there's a technical response where there's only one pathway. But, so there's one? Yes, we will create a single access point, and then so you can make a request at Global Affairs, or there will be a government portal, and then afterwards there will be a security review, and then public safety will take a decision. So what about the processing of this request? The general responsibility will be with public safety. But with the other ministries that will launch the process, I mean, will there be... and if... I think that the final decision will be for the Ministry of Public Safety, but informed by the requests or the applications from the other ministries. But this, my question was a simple one. Imagine these NGOs, how can they be sure that they have seen that over 15 months discussing with various ministries, it's taken you 15 months to draft these 80 pages of documents, even though everybody was in agreement. And these organizations must be asking themselves, how long is it going to take to get my assistance authorized? Because this is a crisis. The situation is a crisis situation. This is what's going to happen. And then I can't really get even a good answer from you and your officials. I just have to say that there is a process that we've designed, as is explained in the bill, and I hope it will be adopted soon. And thank you.
Next, we'll go to Ms. McPherson for 2.5 minutes.
Thank you, Mr. Chair. I think one of the things that we're losing track of with this conversation, we're looking at this within the context of Afghanistan. And of course, Afghanistan was where this became very apparent. But this legislation that you've put forward will have implications as far-reaching as Gaza, Nigeria, Mali, the CAR, Syria, all of these different countries. This is massive legislation change for the international development sector, for the humanitarian sector. I'm not certain, listening to some of the questions I've heard from your colleagues, that they understand that this is not about the aid that you've provided to Afghanistan. This is about changing the way that international and humanitarian organizations are allowed to work in this space. And I have to follow up with what my colleague, Mr. Bernal Duceppe, has said. At this point, this government, Global Affairs Canada, is unable most often to meet their obligations in terms of decision-making on funding announcements, refugee status. This government is not good at making timely decisions. Humanitarian crises happen in places where timely decisions are vitally important. And also, I would just point out that failing to recognize the urgency of that means that the Canadian organizations can't be there. They can't be on the ground doing the work that we need them to do. How can we trust that if this is going through, with all due respect, Minister, I spoke to you, I spoke to Minister Lametti, I spoke to Minister Sejan. Nobody took ownership for this for 18 months. How on earth can I go to the sector, go to representatives from MSF, from World Vision, from so many of the amazing organizations working in this space, and say to them, don't worry, they've never gotten it right, but they're going to get it right this time?
Well, we've been engaging with many of those organizations, including Canadian Red Cross and World Vision and many others. And I assure you that everybody at this table and the ministries that are represented here completely share the concerns that you have expressed around urgency.
I don't want you to share my concerns.
And are prepared.
I want you to make the law better.
And look, Mr. Chair, through you, to my colleague, Ms. McPherson, we are going to get this law passed. We want to make sure we are responding to the questions that you have raised. And once we do that, our commitment is to provide clear guidelines and to support the organization so that we have in place a system that will get that aid to the people that need it as quickly as possible.
Do you worry that this will disproportionately hurt small, medium diaspora organizations that won't have the capacity to go through the hoops that you've now set up?
No, because we will work with them as well. We will do so in a way that is impartial and neutral. And Ms. McPherson, you know me, I'm an open door policy. If there are organizations we need to reach out to, we will roll up our sleeves and we will do the work and we will get this aid to them as
With all
quickly
due
as
respect,
possible.
you're not always
Thank
going to
you.
be the minister.
Let's hope for some time yet.
I want to thank.
Thanks, Carney. That was very kind.
I want to thank Mr. Mendocino for taking out the time to explain and answer questions on proposed Bill C-41. I want to thank the minister for his timely manner, and I'm going to ask the representatives from the department to stay back. So we'll just suspend for a few minutes while the minister.
Thank you very
leaves.
much.
So thank you.
Merci.
several ministries from Public Safety, from Department of Justice and IRCC. So we'll begin with our first round of questions, beginning with Mr. Jennis for 6 minutes. Mr. Jennis, the floor is yours.
Thank you. I'm going to follow up with some of the same questions that I had asked the minister, and hope we can get some answers, some more technical information, I guess. Timeline of an application. Let's just pick a kind of hypothetical application that, let's say, it comes from an organization that is an established partner of the Government of Canada that you've worked with in the past, that's applying to run a agricultural project in Afghanistan. What's a ballpark reasonable amount of time for that application to be turned around?
Well, that's a hypothetical question, but we're not in a position at this point to establish service standards because the time that it would take to process the application will be relative to the nature of the activities that they're going to be performing, the complexity.
Sorry, I'm going to jump in. Come on. I mean, of course it's a hypothetical question, but we're being asked to pass legislation that would create a regime that would involve timelines, and the effectiveness of that regime is dependent on what those timelines would be and whether it's reasonable. So I'd like you to do a bit better than that.
Let me say we share the interest in getting these things done quickly. Speaking from a global affairs perspective, our goal is to get as much assistance on the ground as quickly as possible.
Yeah, but I just want you to quantify quickly. Like what would quickly look like and what would not quickly look like?
Not quickly would be 6 months.
Okay.
That's not quick.
What would quick look like?
Quickly is hard to say because, and again, I appreciate your indulgence, and I'm not trying to be evasive here. The legislation is not complete, and things may change. Where we have low-hanging fruit, so the big organizations that you refer to, I'd like to think that to a large degree, from a global affairs perspective, the work is already in the bag. We know these are organizations that can control their funds, and we know a lot about how they operate. And so, passing it along from global affairs will be a relatively easy thing. And I will also say that as we watch this move,
but again, just like relatively easy. So we're hoping that from the time this legislation comes into force, you could get a bunch of exemptions passed within a month.
In order to do that, we're working on sort of pre-approval packages, so that when it does get passed, we're able to very quickly move to rubber stamping them and saying, yep, move on to the next phase. That happens at Public Safety.
What about an organization that does development work, has charitable status, is recognized by CRA as a charitable organization, has not or does not receive government funding because they're not at a scale where they do that? What would be quickly or not quickly for the perspective of that smaller charitable organization?
If we're starting from scratch, if this is an organization that the Government of Canada has not worked with before, we would require a lot of the same information that we gather for normal project approval processes. There's no additional requirement for this authorization regime than what an organization would normally provide for project approval. So they would provide that, and we would be looking at those conditions. I will say, I appreciate the concern about smaller organizations, but we're talking about projects that will operate in parts of the world that those kinds of organizations are much less likely to be equipped to operate in.
I don't know if that's always true. I mean, I think larger organizations might be working everywhere in the world, but a small organization might have a particular geographic focus. You might have an Afghan-Canadian organization that's only working on development in Afghanistan. So they're much smaller, but they're still working in Afghanistan, and they want to work in Afghanistan, right? So you said 6 months is not quickly, but quickly depends. What would not quickly or quickly look like for that small organization?
Again, it's
has charitable status, so they're known to the government in that sense, but they are not a funding partner.
Right. And again, it's very difficult to provide a figure at this point. I'd like to be able to do that, but until we have the final product, what sort of Parliament decides this legislation needs to look at, it's very difficult to say.
So what kinds of amendments could we propose that would make the final product facilitate a quicker turnaround time?
I think that's up to you. I don't
know. Tell us if I want to propose the amendment that is going to make the legislation as quick as possible. What amendment should I propose?
It depends on what the barrier is. We're looking at a wide range of applications. And I don't
Yeah.
think that there's a single amendment that's going to make this thing lightning fast. I will say
Yeah,
that
I just like this is frustrating, right? Because you guys are the experts, right? We're just lowly members of parliament, and we're asking you to provide us with some explanation of how this regime is going to work. And you're telling us it depends on all these factors, but you can't tell us which factors it depends on or what. Like we're not getting much specific information here, right? We're going to be amending this legislation next week in some form, and so we would like to know what we can put in the legislation that's going to guarantee rapid timelines for turnaround.
So I would like to see that too. Rapid and an efficient process. The reason that I hesitate, and I think my colleagues would agree, to providing an actual date is that we're looking at different things from smaller organizations and bigger organizations. So the kinds of things that would facilitate rapid approval are already in there. I mean, we're not talking about a process that I certainly expect to
But
take
you can't
a
tell
long
us
time.
that, like, is there an estimated timelines? Like, you have estimated timelines for immigration. You have them for
Right.
passports. I mean, you don't always meet them, to be fair. But I mean, there are standards of service that are out there for other kinds of things. From my perspective, you didn't have to create this red tape intensive process. You could have put forward legislation that generally recognized a humanitarian exemption without an authorization regime, but you chose to go this route, and we have the legislation we have. Can you bring forward in writing subsequently estimated timelines and proposals for amendments that are going to allow us to move things along more expeditiously? Can you have
Very
those in writing
briefly.
this week prior to our amendment deadline?
I don't think so, not from us. What we have put in front of you is a package that says this is what the legislation looks like. What we can do is work on regulations and ways to expedite this once we have the full package. The measures that you mentioned before are based on legislation that's finalized and exists, and we can then, as public servants, create a process to implement. What we've proposed represents the best solution to provide an expedited solution. And again, I regret that it appears that I'm hesitating on telling you a deadline, but I think I would be providing false information if I were to say it's going to take 24 hours or it's going to take a week. We're going to make this happen as quickly as we can based on
I'm
the
looking for neither
requirements.
false
you,
information nor
Mr.
no
Janice,
information.
and
I'm
thank
just
you, Ms.
looking
Loden.
for the answers. But I hope we can get some kind of follow up before Thursday when we need to submit amendments in writing. We're on a tight timeline. There's
Mr.
an urgent
Janice,
situation.
you're
So
well over a minute over. Ms. Dillon, over to you for 6 minutes.
Mr. Chair, and I'll continue with Ms. Loten. How does the proposed approach in the legislation differ from the approaches taken in other countries like the US and the UK?
So I can start that answer off, and then I would defer to my colleagues from Justice. I think the first thing to keep in mind is that this is based on Canadian legislation, so immediately it's going to be different than what our allies do. I would also say that the amendments that we're proposing, the legislation that we're proposing, is based on creating an enabling environment within Canadian law so that organizations can operate. They are right now prevented from doing so where there is a terrorist organization in control. So this will allow that activity to take place. But again, it's based on Canadian law. It's not based on the legal framework that is at play among our allies, where they have, for example, a different definition of terrorism or of terrorist organizations and a different means of controlling access by terrorist groups to financing within their legal frameworks. And now I'll just defer to Justice, who may have more to say about how it's different.
I'll just say very briefly that other countries often have a conflation or difference between their sanctions and their criminal code regime, and so it's sometimes hard to compare. So notably the United States, the Office of Foreign Asset Control for many, many years has had a lot of flexibility in interpreting its sanctions and its criminal code provisions. And for example, I understand Australia has used its United Nations Act to implement its terrorism provisions and therefore has flexibility, as we do, under our United Nations Act. So I would say that the administrative and legal context in each country is different. The European Union has directives or regulations that get implemented by domestic law, all of which is to say it's hard to do a direct comparison. Some countries have been more generous, sometimes through effectively regulation that could be taken away, like the United States, which regularly issues and then removes regulations or directives related to their authorities. And other countries have been a bit more crude, if you will, and just had a general legislative carve-out, such as New Zealand.
Thank you so much. And we've been speaking about terrorism as well. It's a huge, huge concern. Could you comment or tell us, the committee, whether this would undermine our ability to combat terrorism in Canada and around the world? The questions for anybody.
Well, this legislation provides additional tool to allow us to better control, the flow of money to potential terrorist organizations. It does not create new positive obligations, but it does create a regime, a mechanism by which these organizations can operate in complex situations across the world where there's a risk of money flowing to terrorist organizations, and making sure that we have quite better controls, better oversight over how the money is flowing, and helping them also creating the right mechanisms, the right control mechanisms, so that they can operate in these regions. So overall, a very positive impact on the fight against terrorism.
And can you please tell us, if this proposed legislation doesn't cause unnecessary red tape, because we do need to help people around the world, people who are suffering. Could your department ensure that this does not become a burdensome process for these organizations? And how can we ensure there's expeditious processing of requests at the GAC and IRCC levels as well?
No, we're quite aware of the needs behind every application. The government has also provided funding in the budget to augment the resources and dedicate to this new mechanism that's going to be in place. So we're going to, obviously, the whole system will be geared up for an expedited process.
Okay, and I also understand that C-41 charter statement was tabled on March 21st and is available on the Department of Justice website. Can you please confirm?
I apologize. I should know that, but I will confirm and get back to the committee. Yes, it should be there.
Thank you so much. And I have another question for Mr. Giguère. Can you tell us, please, the difference between a terrorist entity and a terrorist group, and the rationale for the distinction?
So a listed entity is an organization that's been through a rigorous process of examination, and then has met a certain legal threshold. Whereas a terrorist group organization is an organization whose one of its function, or not functions, but one of its activities is to support terrorist activities, which is also listed, explained in the in the criminal code. So the reason for having both sort of designations in the legislation allows us to have the flexibility to make sure that we are not reliant on a list, a master list, but rather have the flexibility to evolve as the situation on the ground evolves, but also making sure that we're adequately protecting against the risk of terrorist financing. I don't know if Justice wants to add.
Just maybe as a technical point, I'd note that the provision here at issue is 8303B, which is providing information to terrorist group. Terrorist group then includes both parties, both parts, listed and unlisted terrorist groups. So the goal of C-41 is to allow entities that wish, or organizations that wish to apply, to be exempted from potential criminal liability from that provision, to seek an exemption and there's authorization, and that would apply to any group that they are concerned that they might be dealing with, whether listed or unlisted.
Thank you so much.
Thank you, Ms. Dillon. We'll next go to Monsieur Brunel Desepp for 6 minutes.
Merci.
Thank you very much, Chair. Thank you to the witnesses. This is a very important topic. We need responses. We are going to have to participate in a legislative process, and the process, amended or not, we have to have all the information we need. And currently, I think what concerns NGOs is how long will it take to get this exemption. And we're not here to embarrass you, not at all. We just are trying to find out how long it will take, and we want to know what amendments we could propose that could improve the law, and the NGOs want to know how long will it take to go through the process. So it's very important for us and for them. Can you give us some idea of how much time it will take for an organization to be authorized to work in the field. I think that we've talked about it quite a bit already. I think that, and it's difficult to give a firm response. This is still a bill, and we've said here already what we believe will be the process, and so we can't really make any more detailed guess. And the other factor is the administrative efficiency for this regime, and of course we required funding, adequate funding, but we don't yet have all this information. So I understand, as you as I said, we're just trying to get some idea, and I ask the ministers questions, and we always get the response that it's complicated, and with this bill, it's the same thing. And you've taken part in discussions, and if there were some other options that might have been presented rather than C-41, were there any other suggestions for a solution to this problem of authorization? We looked at a range of options, and in evaluating the situation in Canada, we think that this is the best response. Of course, we talked about the possibility of a broader exemption for humanitarian assistance, and we felt that there were other options that were available, and so a number of options, and the government decided in the final analysis that we had to decide between a very broad exemption and a response that would permit humanitarian assistance in specific situations, and without submitting these organizations to the threat of criminal proceedings. And we see that it's quite likely that there are increasing numbers of regions that are under control by terrorist organizations, and this will be aggravated by climate change, and so this will mean that there will be more and more crisis situations. I'll give you an example, something for NGOs. Tomorrow morning, let's say there's an earthquake in an area controlled by a terrorist entity. You have to go in and act and provide assistance as quickly as possible. How can that kind of an authorization be obtained in a very short time? I think that in or during the time that the Taliban have been in control of Afghanistan, we haven't stopped trying to find ways to provide assistance, and I think that we can do the same thing in other crisis situations. But with all the respect that I think there are many organizations that have a great deal of expertise in certain areas, and we're going to have to vote on this bill. We have to be in agreement with our NGO friends who are familiar with the situation on the ground, and I think as members of Parliament, we have to ensure that they can go to work as quickly as possible. I've always asked ministers, and I hope I can get a better answer from you, knowing the problem, how can it be that it's taken you more than 15 months to develop this proposal when we know what the problem is? You participated in the discussions with NGOs, and you had a number of meetings. And is there any? You talked about recognizing that it's urgent to find a response. And how many meetings did you have with people like NGOs who were concerned with this situation? I can assure you that we have been working very hard on this file during this period. Can you give the committee the number of meetings you've had since starting this process? I don't have the figures with me, but I can provide them to you.
Next, we'll go to Ms. McPherson for 6 minutes.
Thank you, Mr. Chair. Thank you all for being here today and for answering our questions. You have spoken about this decision was made based on information that you did receive when you did liaise with the sector, the humanitarian sector. If you could provide this committee with the list of those organizations that asked for this process instead of a humanitarian carve-out. If you could provide a list of the organizations that didn't want a humanitarian carve-out, but instead wanted this onerous task, that would be great. I also have some questions about timing, and I understand you can't answer the questions with exactness on this, but I just very quickly texted a friend I know who works in the sector. She put in a proposal for grant funding in May of 2022. And has now been told that it will be many months before she receives a decision. And I don't blame anyone at Global Affairs Canada. They are underfunded, they are under-resourced, they are overworked. That has been happening for some time. The 15% cut to our ODA is not going to help that situation. But I will say that it does make me very concerned that we don't have the capacity within government to actually do this in a timely fashion. This is a problem. Now, Ms. Loughton, one of the things that you said in your testimony was that you would be asking for no additional information from organizations. Then why are we doing this? If you're not going to get any additional information, why on earth do we need to go through this process? I mean, it's a rhetorical question, obviously, but you can see from my tone that I don't really see why it makes much sense to take the exact information that you already gather and use it to process something. But I think more importantly, one of the things that I'm most concerned with is that humanitarian organizations, humanitarians, people working in the field of humanitarian care are already protected under international humanitarian law. We have a legal framework there. So we were already criminalizing them or making them prove that they weren't criminals with our anti-terrorism legislation. This is making them prove it again. It doesn't make any sense. This legislation doesn't make any sense. And when you add to the fact that A, it doesn't make sense, B, you're not getting any more information that you already gather, and C, we're looking at a situation where you're asking 3 ministers to be involved. A situation where we can't get things through the door when there's 1 minister involved, and now there's going to be 3 ministers involved. How on earth is this even going? Like, how on earth would this even work? It's just not possible. So listen, I'm going to be bringing forward some amendments. I know I'm not asking you questions because I don't think that I'm going to get an answer I'm going to like, but the amendments that I'm going to be bringing forward are going to be to change the wording of terrorist group to listed entity. It's going to be to provide clarity to humanitarian organizations, an amendment requiring the public safety minister to identify and publish the geographical areas that are controlled by listed entities, amendment that changes the 180 days to 30 days or eliminate the period entirely, an amendment to ensure the legislation applies to Canadian citizens, permanent residents, and visa holders. Are you open to these amendments? Will you support amendments like this that would strengthen this legislation?
Okay, I guess the place I'd like to start is just to say you raised excellent point. You already know that. I don't have to say it. We share those concerns, and the way this has been designed so far, I hope, addresses a lot of these things. Just to take one at a time. So the issue about publishing a list of terrorist-controlled organizations, obviously from a diplomatic perspective, that's incredibly difficult to do. It's also very likely that the governments that are listed in a list like that would object, and it doesn't serve any useful purpose. As far as listing...
But yeah, we're going to ask the organizations to?
We're asking them to seek protection from criminal liability from the Canadian Criminal Code. And that's the other point that I'd like to raise. You mentioned that there's already protection that exists under international law as far as humanitarian assistance is concerned and as far as UN and international law is concerned. The Canadian Criminal Code, and we can't get around this, criminalizes any activity that might provide a benefit to a terrorist
Unless you did a
organization.
humanitarian carve-out.
But we aren't able to do that without limiting the kinds of activities that would be subject to that legal provision. So even if you're not doing, for example, we did a lot of work on education in Afghanistan. That's not protected under humanitarian carve-out. So if a Canadian organization were to continue to engage in that activity, they would still be liable and criminally liable within Canadian law. And we want to avoid that. We want to be able to continue to do things that exceed what would normally be considered humanitarian assistance. And we don't want to presuppose where 10 years down the line this kind of situation may go. So we're trying to make this broad and flexible. I know that it seems like it's complicated and unnecessary, but as to the point about information that we already have, we have that for organizations that the Government of Canada already funds, but we don't have it for organizations that are operating on their own behalf. It is not our intention, it is not our job, it is not our mandate to control what Canadian organizations do. But as a Government of Canada, we have to make sure that none of those activities contravene elements of the Canadian Criminal Code that have nothing to do with humanitarian assistance. So that's where I think we're trying to make this open-ended and broad. And I totally understand we're looking at this from the outside. It seems like we're adding layers of complication.
But to be perfectly honest, I'm not looking at it from the outside. I'm speaking to the experts within the field that are doing this important work. In fact, I would say that perhaps you're looking at it from the outside because realistically, we see that other countries, and I know you've used the United States as an example, but there are countries that have very similar legal systems to ours that have chosen a humanitarian carve-out. That is very, very possible for Canada to do. And we could carve out for development organizations as well. It's a choice that you have made directing the government to make this very, very onerous. And I'm not certain that it actually will adhere to international humanitarian law. I think that there will be a point where the government will have to defend itself, and I don't think it's defensible, which makes that very difficult for all of us as parliamentarians to vote for legislation. But yet, it's the same situation that I was saying to the minister. You've put us in a situation where 18 months into a crisis where millions of people's lives are at risk. So we either take broken legislation that won't do what we need it to do, or we let people continue to starve. And that is an untenable place to put any parliamentarian in. It's obscene.
Well, right, and with all due
Very
respect,
briefly.
we have continued to provide humanitarian assistance throughout, and I will defer to my justice colleagues on whether or not this matches international law. What this does is an enabling function for Canadian organizations to allow them to operate where otherwise they would violate the Canadian Criminal Code, and there's no denying that. It's not an option. That's a piece of Canadian law, and we have to address it as a reality. And
Thank
what
you.
we collect from organizations is the information that we will use. We need additional information from organizations that we don't fund. And again, we're as committed as you are to making this as streamlined as an operation as possible.
Thank you, Ms. McPherson. We'll next go to Mr. Van Popta for 5 minutes.
Thank you to all the witnesses for being here, all experts in their field. We're talking about Bill C-41, which would open the door for humanitarian aid by Canadian organizations that are otherwise prohibited from doing work in certain areas of the world on account of Canada's strict anti-terrorist laws. Now, generally, we agree with that. But as you heard from a number of the questioners, there's deep concern about the government's apparent slow reaction to a crisis, particularly in Afghanistan. And I'm looking at the report of the Special Afghan Committee that was issued sometime in June of 2022. And I'm looking particularly at evidence given by Michael Messenger at the committee on March 31, 2021. So more than a year ago. This is what he had to say. Based on external legal advice, our understanding is that the Minister of Public Safety could provide an exemption to the restrictive provisions through Section 83.09 of the Criminal Code, existing legislation. He goes on to say, in fact, we believe he and his department have an urgent obligation to do so. So my question is, why wasn't Section 83.09 used? Would it have been sufficient? Did World Vision even make an application for exemption at that time?
Well, the short answer is I'm not sure where that information came from, but it's not correct, unfortunately. The power in 8309, as my colleague can elaborate on if you'd like, is dealing with, just looking at it now to make sure I recite correctly, to carry out a specified activity or transaction that is prohibited by section 83.08. 83.08 is not the provision that is at issue with the activities involved here. This is 83.03b, which is the area of concern. So there is no power in the legislation presently to do that.
Just to add to what my colleague has said, and in fact what my boss has said, 83.08 essentially freezes property owned or controlled by a terrorist group. It makes it essentially a crime for someone to own, to deal in property that's owned or controlled by a terrorist group. 83.09 allows for the Minister of Public Safety to authorize the release of that property that has been frozen, subject to terms and conditions that the minister wishes to impose. Here you're talking about a different situation, because at this point in time, the property is not owned or controlled by the terrorist group. You're providing property that could go to the terrorist group, or that would go to the terrorist group. And so 83.09 would simply have no application to the offense in what is currently 83.03 paragraph B, which makes it a crime to provide property directly or indirectly, knowing that it will be used by or will benefit a terrorist group. So it's a completely different situation.
Good. Okay, thank you. That's a good answer. There's been quite a bit of evidence about the process that is being proposed under C41, and that is, if my understanding is correct, that an applicant for an exemption would have to go first to the Minister of Foreign Affairs and or the Minister of Immigration. I'm not quite clear on what the process is, and why does it have to be that process if ultimately the decision is going to be in the hands of the Minister of Public Safety? Why not go to the Minister of Public Safety immediately to speed up the application process?
So the application process, applications are presented to the Government of Canada, and then depending on the nature of the activity that they're requesting an authorization for, it would be deferred to Global Affairs in the first instance, or IRCC if it were about safe passage. The reason for that is because Global Affairs and IRCC are better able to assess the preparedness of the organization and the validity of the application. It's entirely separate from the assessment that public safety will lead on that has to do with national security. So it's a question of using the right tools within the Government of Canada's toolbox to respond to the request that's being made by the entity in question. So, and again, hopefully we can provide that answer very quickly for organizations that we know very well.
I would add also that this is a measure to streamline. So if you would imagine that there would be a consultation by the Minister of Public Safety with the ministers of GAC and or IRCC to get their perspectives. By having the application go first to those ministers, it eliminates one of the ping pongs and is part of the streamlining in order to attempt to have a more efficient system.
No, my next question will take a few minutes. So.
Thank you, Mr. Van Vopta. Always very timely and efficient. Next to Ms. Diab for 5 minutes.
Thank you very much, Mr. Chair, and thank you to our witnesses for being here. It's not every day that we have such experts from so many different departments from the Government of Canada, so we really value your expertise that you bring to the table. This is complicated. It's quite complicated. We know from what the minister said that the bill is crucial to bring a humanitarian crisis in Afghanistan. But we also know that it's not just Afghanistan, that there's many parts of the world that could require and that do require humanitarian aid. We also know that we do have to balance. We do have to balance, and I think Canada, in my opinion, is known very much for its international development and aid for countries around the world. But we do have to balance and mitigate the risk by potential terrorist groups, known and unknown, because we know they exist everywhere. So I guess there's been a lot of talk in terms of, and of course, this is all new to me. I didn't sit in any of the other committees that predated this. So, of the bill that is proposed before us versus another alternative that Ms. McPherson and perhaps others have talked about. Can you sort of, in a simple, non-legalese, sort of simple language as possible, explain the difference and explain how you believe you've arrived at the right mix? I don't know who to ask, but perhaps I'll go to public safety first, because I'll start with that first.
Well, in very broad terms, what we're offering is the regime that offers the best balance between the need to protect against terrorist financing, but also the delivery of humanitarian assistance and development aid. So, if we were to simplify to the extreme, on the one hand, having a humanitarian carve-out will not provide the full flexibility that this regime will offer, because it also includes developmental assistance and also safe passage. But to build all these elements into a carve-out would actually be, for the government of Canada, be a risk that will be difficult to manage in a sense. So the balance of that is having the right controls in place and making sure that the organizations operating in that environment have the right protection against the the potential criminal liability under the criminal code, which exists right now, and making sure that the government has the right assurance that the money will not be flowing to terrorist organizations.
So would you believe, and I'm going to ask, I guess, the marrying or the bringing together of the three departments here, IRCC, Global Affairs, Foreign Affairs, as well as Public Safety, because of it's not simply humanitarian aid. It could be allowing people to come, like we have, and we've just welcomed 30,000 refugees from Afghanistan. We've certainly welcomed many others from other countries in the years ahead. So how do you intend to have these departments work together in order to facilitate? And can you sort of help us out to try and understand that it's not really complicating the system by having all these departments intertwined in each other's business?
I guess my quick answer to that would be to say that we work together all the time. The Government of Canada operates through a series of interdepartmental committees, and they help us to bring the expertise that we need to the table when necessary and to provide evidence-based and informed information up to ministers who make decisions. So it's not a new development at all. I can think of three within my own area, the counterterrorism and crime, that depend entirely on interdepartmental collaboration, and it works very smoothly.
In deciding to grant an authorization, we heard that the Minister of Public Safety must consider any mitigating measures to minimize the risk of benefiting a terrorist group. Can you give me some examples of, or terms or conditions of how that risk can be minimized?
There's a broad spectrum of mitigation. One of them could be the frequency of controls. One of them could be some transparency in the flow of money. So it could be limiting the operational area where they will be deployed. So there's actually quite a long list. I don't know if no?
Anyone else would like to add anything on any of the questions I've asked? From any of the other departments, to sort of help shape a little bit more this discussion around the table as we come to the near of our hour. We're actually out of time. So thank you very much. Much appreciated.
Thank you, Ms. Diab. We'll next go to our last round of 2.5 minutes to Monsieur Brunel Duceppe for 2.5 minutes, and then Ms. McPherson.
Monsieur le Président.
Thank you very much, Chair. Maybe a slightly more technical question. With regard to 41, from Foreign Affairs or Immigration, you say that this bill applies to, according to the text, applies to a situation in a zone controlled by a terrorist entity. And I want to understand what you mean by the criteria used to decide if the objectives of the bill are achieved. First of all, I think this is quite normal language. We must meet criteria like being able to manage funds. There is other criteria, and there's a process for evaluating this. But yes, of course, this is very normal. But in the law, this bill, the government says any other requirement set out in the regulations. What other additional requirements might be set out in the regulations? This is very important, for example, for NGOs who will have to know this type of thing. They don't know anything right now. With regard to the adoption of the law, we will work with the organizations that are present in the field and take into account their experiences. And we will don't have that information right now. We will get it in the process of consulting them. Have you consulted any during the preparation of this bill? Can you tell us if major organizations have been consulted? For example, Médecins Sans Frontières, would they have been consulted? And the regulations are not part of the bill, part of the law. These will be developed after the adoption of the law. But you must have. Thank you very much, Mr. Brunel.
Thank you, Mr. Chair. I did say to Minister Menacino, and I'll say it to this group as well, I recognize the job you're trying to do, the balance you're trying to take, and it is my belief that the balance that you've struck is wrong. And I say that knowing that support from all opposition parties believe that. So of course we will be bringing forward amendments to try to fix this legislation because, as you've heard from colleagues from all three opposition parties, we just feel that this balance is wrong. That you've brought forward legislation that will in fact hurt our humanitarian actors, those actors that I think all of us should be doing everything we can to support. So I do want to know, if we bring forward an amendment for a humanitarian carve-out for those organizations that are strictly working in the humanitarian sector, that are strictly under the IHL, would you recommend that the government accept that amendment?
My own view is that would limit the legislation. A humanitarian carve-out prevents different kinds of activities that we want to make sure would be covered. So I think it would be unlikely, but again, that's not my decision. My own view is that the shape that we've given to the proposal in front of you provides the most flexibility and prevents us coming back to this table a few years down the line when the situation evolves and redoing the amendment. We want it to be as broad and inclusive as possible, and that's why an exclusive carve-out, to me, speaking entirely personally, isn't the best way forward.
But a humanitarian carve-out would ensure that those organizations just doing humanitarian work would be able to work faster and be more efficient in a system where we know, because the experience has shown us time and time again, the government is not good at moving quickly. We don't have trust in the government to do those things for very good reasons. I think we can all agree. So that humanitarian carve-out would let our humanitarian organizations get on the ground, help people in the minutes, the hours, the days after a humanitarian crisis where it's necessary, and the legislation would still be in place to meet the balance that you seem to think is necessary with regards to international development activities like education and longer-term projects. So one would think that this would meet both your needs and the needs of the humanitarian organizations.
I guess that's
Very briefly, please.
being provided to a humanitarian organization is what we hope is already contained. It does not change anything if we include broader categories.
Then why have it?
But why not have the other categories is my question.
I want to thank everyone. That concludes our round of questions. Thank you to all the witnesses. I just have a few two means of business left. There's just a motion for deadline to submit amendments that for the purpose of the clause-by-clause study on Bill C-41, an act to amend the criminal code and make consequential amendments to other acts. The deadline to submit amendments be Thursday, April 20th at 5 p.m. Is there someone proposing the motion? Sure. Yes.
Can I just confirm? I mean, obviously, it makes sense for us to give notice of amendments as much as possible, but my understanding of the rules is that we are still able, if there are discussions that happen over the weekend, we're able to bring amendments that of which notice has not been given, or propose sub-amendments on the floor as well.
Well, I think by Thursday, April 20th, that's suffice.
My understanding of the rules, though, is that is required for getting into the amendment package for distribution, but that we will still have the opportunity to move amendments on the floor. We're going to get all our amendments in advance if we can, but there may be discussions that happen among parties over the weekend, and we're on a tight timeline here. So
that's fine.
Yeah. Okay.
Everyone okay with the
with that
motion?
understanding? Then that's great.
Okay. All in favor? Aye. Okay. Next, that in relation with the committee's study on Bill C-41, an act to amend the criminal code and to make consequential amendments to other acts, the draft budget to the amount of $27.50 be adopted. Anyone propose the motion? Anyone proposing the motion? Yes, thank you. All okay with it? No objections? Thank you. Okay, that concludes. Thank you, and have a good evening, and see you all on Wednesday.